very much. There we go. So, welcome. I'm Richard Goff. This is the Experts at Work webinar, which is dedicated to mediation, resolving disputes before they become grievances. And it's for members of all three of our networks, as I'm sure you know. We're recording this session, as I say, and it's a big welcome, as I say, to John Scott of Aboon Mediation. Thanks to the two network members who kindly recommended John. John's a highly experienced mediator and former HR director with PwC and Lazard, amongst others. He's also a magistrate. And John will be taking us through some examples of where mediation can work, red flags, how mediation compares to grievances and litigation, the process of mediation itself, and where it can save your organisation money and you, as an HR practitioner, both stress and time, which sounds good to me. So John will be speaking probably for 20-25 minutes or so, something like that. We'll have time for Q&A at the end. No breakout rooms for this one, with a hard finish at 11:45 a.m. Do send us questions and suggestions throughout. We'll always have to see those in the chat. Please put yourself on mute if you haven't already. I think you will have, actually. And John, nice to see you. Thanks a lot. The floor is yours, sir.
Richard, thank you very much for your kind introduction and indeed the invitation to speak about something about which I'm passionate. And I should explain a boon. A boon is a Scots word, meaning if you get a boon, an illness, you recover, or you get a boon, a disappointment, you move on from it. And it captures the dynamic of a mediation, because typically when people are in a dispute, they're stuck in the immediate present or the past with their fists literally or metaphorically up in the air. And part of the process of a successful mediation is to allow people to move on from that place and engage with the future rather than the past or the immediate present. Essentially, what mediation is the involvement of an independent third party. And I operate at the early stages of disputes. I don't do work where there's a ton of lawyers in the room and the mediator is a senior barrister or a retired partner from a law firm. I do it at early stages. And it's my job to do two things, really quite simple: to facilitate a discussion between those involved, either between colleagues or between a colleague and the employer. It's typically a discussion that they don't necessarily want to have, but unless they have it, then the dispute itself will not be resolved and will likely escalate in a manner which I'll talk about later. And then the second aspect of the mediation is to culture negotiated settlement. And I was saying to Richard earlier, I have to put my history of upwards of 25 years in human resources behind me when I'm dealing with a mediation, because it's not my job, as it used to be, to intervene as quickly and as aggressively as possible on the part of the employer. It's my job to bring people together and for them to mutually resolve the difference. In my experience, most workplace disputes are suitable for mediation. There's a few exclusions: bullying in the workplace, sexual assault, sexual harassment. I don't think those are suitable for mediation. But crucially, the vast majority of the ones that I have dealt with tend to be relationship-based, where the relationship is not strong enough to deal with a difficult issue, which in the first instance represents a little spike in the relationship. If it's not dealt with effectively, that spike will escalate over a period of time and eventually explode around everybody. And I'm always surprised when people are surprised that it's exploded, but that is the inevitable consequence of a discussion that's not had in an issue that's not addressed on a timely basis. So most disputes that I deal with are relationship-based, almost regardless of how they're described to me when I'm briefed about the mediation. The process itself is endlessly flexible. I've done mediations online. I've walked along a canal in Leeds. I made the mistake once of sitting in a park in central London that was next to a building site, and then the building site sort of kicked off, so that didn't quite work. But it's endlessly flexible. My preference is to approach it as follows. I'll sit one-to-one and confidentially with everybody involved, and I'll explore 5 or 6 areas with them. What brings you to this point? What do you need to do to resolve this? What does the other person or what does your employer need to do to resolve this? What does success look and feel like? What happens if nothing changes? And I have to be careful with that question, because almost always, regardless of gender, of the folks in the room, there's always high emotion around. So I ask that question with care, and I always have a supply of tissues with me, regardless of where I'm going. And it's terribly easy for us as HR professionals to forget about that emotion that's in the room because we're dealing with process and we're dealing with people who are unhappy all the time. But it's always there. And I'll then say to them, and this is very important, the next time the wheels fall off the truck, as inevitably they will, what are you going to do between you to resolve things constructively and swiftly without escalating it or without engaging in a sharp exchange of emails? I think one thing I've realised as a consequence of being a mediator is that emails are really not good for dealing with anything apart from asking a colleague if they want a cup of coffee. They should most definitely not be used for exchanges on issues of substance. Those one-to-one conversations are terribly helpful, partly because it allows people to talk and to emote, but it also helps them recognise that the wide blue ocean that they think is between them and their colleague or them and their employer is actually a mucky little stream, and the best thing that they can do to resolve that is to get into the stream and have a conversation. And one of the joys of being a mediator, and I must say one of the joys of no longer being a HR director, is that I can have discussions with people that you can't have, because otherwise you might get a constructive dismissal claim. So I'll judge my interventions in this respect quite carefully, but I can say to people, listen, by the time I arrive, your employers, they're running out of patience, they're running out of options, and they've probably had enough of your behaviour. I'm doing an investigation at the moment. Sometimes I do investigations, and I'm going to have a conversation along those lines with the two individuals involved. And I'll say, in a mediation, this is your opportunity to resolve this matter that's causing your employer such trouble. And it's your only opportunity. So put your shoulders to the wheel and make sure you resolve this. Because if you don't, we need to recognise that what's going on currently is unsustainable. If that's the case and you cannot resolve matters, then somebody else will come along and resolve it for you, and you won't necessarily enjoy that experience. So it facilitates an exchange about the realities of the situation. And as I say, I'll use that quite carefully, but oftentimes it brings people to the table. Some years ago, I did one between two PAs who sat on the executive floor of a large professional services firm, and they were behaving accordingly. And I took it upon myself to tell them both that if they were in a smaller, much less profitable organisation, then the likelihood is that they would both be disciplined for their behaviour. I think I was feeling particularly punchy that day, but it seemed to work, and they resolved things. There's then maybe a few days between those one-to-one conversations and a joint meeting, and typically I'll open that by identifying the areas of mutual agreement, even if they feel they're mutually disagreeing on something, and I'll point to one or two areas where I think progress can be made. And typically over a 2 to 3 hour period, then they'll arrive at an agreement which I'll document in manuscript form, and something like 70 to 75% of them will resolve themselves in this way. And that's no reflection on my skills as a mediator. That's a typical success rate for a mediation. And if it doesn't resolve, then two things will happen. One, sometimes the discussions will continue and will lead to a resolution. Or alternatively, there's then conversations to be had about what happens next, recognising that the current situation is not sustainable. And in many cases, there's a without prejudice conversation, and one or both of them will leave. It's not typical, but neither is it unusual. In my experience of mediations that don't work, that then lead to a without prejudice conversation, is that the without prejudice conversations are much more constructive and are swiftly concluded because the groundwork has been laid. Now, I'm not suggesting that's guaranteed of success, but at least it opens up the opportunity of having those sorts of conversations. I'd said to Richard, I'd talk about the red flags And these are the things that make me worried in advance of a mediation, and will occasionally oblige me to have a conversation with my client and say, this cannot happen. And here are the red flags. Sometimes I'll sit with people and they take no responsibility whatsoever for the car wreck that they're in the midst of. They will blame everybody else. It'll be the culture, it'll be the technology, it'll be their colleagues, it'll be the director, it'll be international capitalism or whatever. But it's not their fault. And I'm then obliged to have a conversation with my client to say, I think you need to have a little chat with your colleague. And if it remains like that, if it remains a one-way street, as it were, we cannot proceed. We really cannot proceed. Secondly, I always ask that the mediation is sponsored by somebody in the chain of command, as it were, above the folks who are busy slugging it out. And I do that for two reasons. One, that's where responsibility for the dispute lies. And two, the mediation is not an HR initiative. And that's no reflection on HR practitioners on the call. You're there to help facilitate the resolution, but the ultimate accountability lies with a person in the chain of command who typically, in my experience, hasn't dealt terribly well with a dispute at all. And that's a common feature, I think, in most of the mediations. It's usually a failure of management or leadership. If that person refuses to sponsor it, I will typically walk away. And on the occasions when I've continued, it's bitten me in the bum. Because nobody anywhere in the organisation has taken responsibility for it. And if those people who are in a dispute sense that, it gives them more freedom of movement. If there's mental health issues around, sometimes the mental health issues can run in tandem, or dealing with the mental health issues appropriately can run in tandem with the mediation. But my preference is that the mental health issues are addressed as a primary matter of urgency, and whatever happens next by way of mediation can happen afterwards. Sometimes in the nature of discussions, people will share with me information that they haven't shared with their employer, and with their permission, I can then escalate it, and we might then decide to put the mediation on hold. But mental health issues tend to be, and understandably so, a priority rather than the mediation itself. And the final one, and I think this applies to larger organisations rather than smaller ones, is if somebody has been on long-term sick leave. There may be a dispute about the return to work, there may be a dispute about insurance benefits or whatever, but what is common is that as a function of being away on long-term sick leave, where effectively the care of that individual can be outsourced to medical professionals, occupational health teams, and insurance companies, then the relationship in and of itself has already taken a beating because of that process of outsourcing. As I say, these red flags don't stop the mediation from continuing. It just provides an extra challenge and may well require some further intervention on the part of leadership or human resources. I said to Richard I'd talk about grievances, and I always have to be terribly polite here, because fundamentally my view is that grievances, in the vast majority of cases, are an absolute and utter waste of time and money. Now, I should say, I've never run a grievance. I've never been a party to a grievance. I confess I haven't practiced as a practitioner here in the UK since 2010, and I may have gotten off lucky, but my preference was always to have a conversation. I'd always have a couple of favourite coffee shops near where I worked, or a favourite restaurant. I remember taking a new HR colleague to one of my favourite restaurants in Smithfields in central London. And I was explaining my approach to having conversations about people's exit. And she's paused in the middle of the street in front of the meat market and said, "John, you've just hired me. Are we?" I said, no, it's fine. It's fine. This is a celebratory lunch. This is not an exit lunch. So I've never had a grievance, never dealt with one, and I've never seen the need to do one. But I realised that the tide had turned against me when I was in the Middle East, and my senior manager said to me, one of my senior managers said to me, "I've just had a request from a colleague. about a difficult matter. And I said, I can't talk to you. Here's a grievance procedure. So I said, well, that's really unhelpful. The next time you do that, I'll give you a one-way ticket back to the UK, because all you've really done is set everybody up for failure. I look upon grievances not as they used to be back in the day, an informal means for resolving grievances locally, is now, sadly, a means of advancing litigation. And that's unfortunate. They're not a good means of resolving disputes. People who take grievances very rarely walk away from the findings, usually 6 months after the hearing, with a spring in their step. The same thing will happen again should they appeal. It's an inordinately expensive process for the employer. I did a piece of work a few years ago for a professional services firm, and partly because partners were involved in hearing the grievances, the cost to them was about £12,000 to £15,000 for a grievance, which is a hell of a lot of money for a tool that really doesn't work and is no longer fit for purpose. So my advice to clients is avoid grievances wherever possible. And if they fail, as often they do, then you might like to think about mediation as a more constructive way forward, ideally before an employment tribunal case is lodged. And let's come to that. They're now inordinately expensive. I think employers are out of pocket probably to the tune of about £80,000 to £100,000 before they even get to the employment tribunal. Individual members of staff are probably out of pocket to the tune of about £20,000 to £25,000. And that was the figure quoted to an acquaintance of mine who I referred to an employment law lawyer in the Midlands. That's not a London price, that was a Midlands price. And like most aspects of the judicial system in this country, the tribunal process is broken. So if you were to lodge a claim today, you'd be very lucky if it was heard in 2025. And if it was a complex case, it'd probably take longer than that. And in my admittedly biased views, there are few winners in tribunal processes. Even people who win or employers who win, if you have a quiet conversation with them 3 to 6 months afterwards, they will likely say, we won, but it wasn't worth it. The only real winners are the lawyers. So I've got 2 minutes left. My view, and I admit, I'm a convert, so I'm slightly biased. Mediation is swift, takes no more than a day. It's confidential. There's no information in the public domain. If it's handled carefully, it's confidential within the organization. It seeks to protect relationships and to bring them back from the brink, rather than necessarily destroying them or finishing them forever. There's a high success rate, as I've mentioned, and it's exceptionally cost effective. So I would normally charge no more than £2,000 to £2,500 for a mediation. I concluded a grievance hearing earlier this year. Now, admittedly, the comparison is not a perfect one, and it was complex, and it took about 7 months, and I billed about £30,000. So go figure. From the cost effectiveness aspect, it's hugely valuable. And crucially, and I speak to you all here, it reduces the stress and time upon you by resolving things as quickly and constructively as possible and avoiding tools, grievances, and employment tribunals, which, as we all know, are costly, but also massively stressful for everybody involved. So with that summary of the benefits of mediation, I'll stop talking for a while and we can have a conversation. So over to you.
Thanks, John. Appreciate that. I love the way you articulate some of those things. That question, what happens if nothing changes, I thought was a particularly telling one. Before I throw it open to questions, can you give us a little bit more about what you see works well when you mediate? Give us a bit more on that, the sort of questions you ask, the sort of things that you tease out.
That's a good question. I think two or more people in the room that want to have the conversation. That helps. But each of the questions I tend to explore further because people tend to be more open with me. And I can say to them, how has this left you feeling? What is it about the relationship that doesn't work? You know, on a scale between badly beaten up to fundamentally broken, where is the relationship? What do you want from this process? And sometimes I'll push a little bit on that, because sometimes people will say, well, I want to exit. And I said, well, you know, we could have a without prejudice conversation now if you want. We could start off a conversation about what that exit might look like. And I'll deliberately but carefully explore how people are feeling, because it's worthwhile reminding all of us that when somebody's in a dispute at work, it bleeds into their personal life. It absolutely bleeds into their personal life, and it affects what they do, almost regardless of how they try to sustain it. It casts a long shadow over their lives. So it won't be unusual for people to say to me at the end of the one-to-one conversation, I feel better, or this has felt a bit like therapy, which worries me because I'm not a therapist. But clearly there's an exchange that they feel valuable, and the start of a long journey back to rebuilding a relationship with their colleague or with the employer. Because even when the relationships are a bit beaten up between colleagues, the employer gets it in the neck because they haven't moved quickly enough, or because they have some responsibility for the situation that the individuals find themselves in. So it's the sort of work that HR practitioners are used to doing, where there's that sort of discursive, iterative process, recognizing at all stages that I'm on their agenda and I'm not on mine. And I can get, one of the reasons I get to do investigations and grievances is I can get quite punchy. I'd had to resist that temptation when I'm doing mediations, because I'm on the person's agenda. If I think they're being abusive or they're talking nonsense, then I'll find a polite way of just, waving my finger at them. But I'm on their agenda. And it was interesting, in the training that I did, there was any number of lawyers there who were litigators. They struggled with this. They really struggled because they wanted to get in there and sort things and say, no, you're wrong. And from a point of view, in reality, that doesn't matter. It doesn't matter. What matters is the people in the room. And oftentimes, I don't deal with relatively junior people, partly because I think the costs make me too expensive for that. And it's clear I've been around the block for any number of years. Oftentimes I'm dealing with really senior people who find themselves in situations that are really quite embarrassing professionally. And sometimes I just want to explore that. I had one recently. I said, to the best of my knowledge, you're not on minimum wage and you're not a graduate. So what's happened? You're in a really senior position, leading a major project, and there's somebody along the corridor there who's crucial to that project, and the two of you can barely talk to each other. Talk to me.
Good example.
That's a question. Yeah.
No, that's a very good answer to the question. Thank you very much, John. So please do raise your hands, or either literally or in the on the top bar there, third from left. Jen Lawrence. Jen, nice to see you. Thank you. So you asked about the psychometric tests.
Yes, so it was just a really quick question, John, about kind of helping people see and understand other personas, behavior traits, etc. I just wondered if you endorse the use of things like insights and other psychometric tests to support your mediation work, or whether you think that actually that's quite difficult from a trust and creating psychological safety anyway.
That's a very good question, Dan. And I hadn't quite realised that occasionally mediators use psychometric tests until very recently, and I puzzled about it. And I think my view is it would serve to stretch the timetable in a manner that's not necessarily helpful. And also, as you've probably gathered already, I'm a bit of an activist. I like to get in and get things done. And I'm not sure the psychometrics would get in the way, but given that it appears to be used by mediators, and I'm guessing successfully, it must fulfill a role. I suppose I also start from a point of some intellectual skepticism about psychometric tests generally. I'm qualified in a couple of them, and I haven't used them in years. So there's intellectual skepticism, and also when I get briefed, I want to go to work, and I don't really want too much in the way. I don't want anything to get in the way of that. So I don't use psychometrics. I don't use a mediation agreement. I want to keep it as low level as possible in terms of how I intervene, as it were. I hope that's helpful. I'm sure there's some biases in there on my part, but I don't use them. But neither do I deny the value in mediations, because I recognise the flexibility of mediations.
What do you think, Jen? Do you find them useful generally? I mean,
well, yeah, I have used it once, and I have found it to be useful in that situation where people just were coming at things from a different perspective. So whether it was about somebody who just needed more time to reflect before they could answer, the other person getting frustrated because they weren't actually responding quick enough, and they just polar opposites sometimes of the circuit of psychometrics. So I think it just helped people realise to be able to then notice their own biases and so forth. It worked in that instance, but I just didn't know if it was common practice.
Great. That was a very good example of it working. I need to go and reflect on my biases, Jen. So thank you.
Thanks, Jen. Lauren, hi.
Hi, John.
Hello.
I think you made a great point around how, specifically with senior people, you can have that really kind of direct conversation and be like, why would you not make this relationship work?
Yeah.
And I see something similar within our senior leadership team. If there is ever a problem, they do engage with it. The problem that we tend to have, or that I tend to have, is that we have a lot of junior people within our organisation who are probably paid circa like late 20s to mid 30s.
Yeah.
And when they have an issue with someone, and they're engineers, so they're lads in the workyard, when they have an issue with someone, their options are, they feel their option is either to raise a grievance, and they see that as a bit of a lynching tool, to be perfectly honest, hold people accountable, or if it's not that, it's then trying to hold them accountable in the workyard or just outside the gates. So trying to sell mediation to them can be really difficult, because they're sometimes what they're looking for is not to make that relationship more productive. So I think any kind of tips or anything that you've seen that's worked in terms of selling mediation to that kind of population would be really helpful, because I totally agree with everything that you've been saying, by the way.
It's a difficult one, Laura, and I suppose there's nothing you can do to stop them from having a sharp exchange at the gates, is there?
No.
But I suppose if they want to step towards grievances, then I will always say to people, be very careful what you ask for. You're not going to get what you ask for. You really aren't. And then after that, it's just a conversation about what it is that they want in terms of their relationships with their colleagues. But I get it. There are communities of people where mediation is much more difficult, particularly if they've got their own ways of resolving disputes. But if they can tolerate, if it's the case that the relationship with a colleague becomes increasingly intolerable, then they're going to have to deal with it. And I think the fact that if there's a difference of opinion, there's no magical process of osmosis that's going to make that go away. It just doesn't exist. So they either have to deal with it or live with it.
No, I like that. I like that kind of because you are right. The grievance process, I don't think anybody ever really gets what they don't get it. They don't get what they think out of it. I just think with them where we have done mediation, it actually has worked, because you are able to ask those questions. Whereas with grievance, it's kind of just one side versus the other. It's just trying to get them to commit to it.
Yeah, exactly. And if it's unionised, then I've worked with union officials who are big fans of mediation. I've worked with others who think I'm the spawn of the devil, because it gets in the way of this sort of negotiating process. But I think there's always a way of having that sort of conversation. And sometimes I won't use the M word. I won't use the mediation word. I'll just say, I think we need to have a conversation.
Yeah. Thank
John,
you.
Oh, sorry, Lauren. I was just going to say, what about your question from earlier, which I liked? What happens if nothing changes? Is that something you use to persuade people of because you can get into a routine of disagreement, I presume, almost. It becomes the norm.
Yeah, exactly. Yeah, quite. And it affects everybody. You know, it casts a long shadow. So if people are not getting on in the workplace, it casts a shadow, and it's unfair on other colleagues. And it's a distraction for management. It's an absolute distraction.